You've had some excellent speakers who have covered the wider topic of sort of the wider issues surrounding Brexit. We've had some mention just now from Pat of the implications sort of going down to more what I'm going to say sort of like case study with the supplements. So I'm not going to look at the wider issues. I'm going to be going down into the sort of the nitty-gritty, possibly answering or giving direction to some of Pat's sort of questions or concerns. But the thing to remember is that at the moment, nobody really knows. So all we can make is educated guesses based on meetings we're attending, the discussions with the agencies that we're having, and that's all we can really do. So I'm not going to read the definition, but the key thing is supplements, and I'm sure many of you have come across them one way or another. They have the same sort of form as medicines. They can be in tablets, capsules, small powders, liquids that you take with like a dosage spoon, but they're controlled as foods. Food supplements are foods, and they are treated as foods. They can contain vitamins and minerals, and they can also contain many other substances, as Pat said. So you can have, fish oils, you can have plant extracts, plant powders, various proteins, all sorts in them. Now, I will dispute people who say, I'm sorry, this is I'm going to dispute something that said that there was more, they weren't regulated enough. Actually, food supplements are highly, highly regulated. The problem is the enforcement side. They are highly regulated, the laws are there, but enforcement is not enforcing those laws. So when it comes to these other substances, an awful lot of those other substances could be controlled from the Novel Foods Regulation, for example. Because I will agree there's an awful lot coming onto the market, the UK market and other EU markets, that really, they are novel ingredients. So they should be controlled under the Novel Foods Regulation. Now, the UK has recognised that, and in their implementation of the new Novel Foods Regulation that's coming in, it applies from January, they have actually put in specific enforcement measures that gives enforcement far more control of products containing the novel ingredients. So, as you can see, there are a wide range of laws controlling food supplements. Many of those laws are control all other foods, because food supplements, being foods, are controlled by all the horizontal laws that control foods. Then you also have sort of specific laws. I've just realised there's a slight transition. My S from supplements has gone down. We have the Food Supplements Directive, which obviously is very specific to foods, and then in certain laws like the additives and contaminants, you will have specific mentions of food supplements. I'm not going to cover all the possible changes. I mean, there's changes that might occur on the labelling side, potentially, with divergence. Initially, we have been told not to expect any changes. We have been told that initially, the only changes they are intending to make is how to deal with the issues such as EFSA. So much of the legislation refers to the authoritative body. What are we going to do? Do we still look to EFSA, or do they try and expand the existing scientific bodies we have in the UK and create some more? That's an unknown. But we have been told that that's the kind of change that they will have to make. They are not looking to make any major changes to the main points of the legislation. So from day one, we shouldn't see much difference. And we probably won't see much difference for the first few years, because it's going to take, they're telling us they won't accept any changes or requests for changes leading up to day one. They will only consider discussions on that after day one. And of course, if you're going to want to implement any changes, and to be honest, I think it's going to be chaotic after day one, but if you want to implement any changes, then obviously we're going to have to go through the lobbying process, the provision of information, getting together with other members in the food sector to, if there's common ground. So I think it will be a few years before we start seeing divergence. And the biggest fear with divergence is obviously how that will affect our existing market with the EU, because an awful lot of the UK trade for supplements goes to the EU. We also get a lot of ingredients and also sort of supplements being made in the EU and then being sold under brand names in the UK. So it's going to be an interesting situation. But I'm going to focus to say there are currently ongoing issues that we're not quite sure, because they are still under discussion and they have not yet been put into regulations. And the way the discussions are going for some of them, they won't be going into regulations until after March 2019. Quite what's going to happen with those and how they will be implemented, if at all, in the UK. So the 4 areas I'm going to look at was contaminants, additives, the Supplements Directive, and health claims, specifically with botanicals. So contaminants, I'm not going to go into any detail. There are various issues ongoing, focusing sort of current 2 main focuses are looking at fish oils and botanical issues. So we've got 3 MCPDs in fish oils and pyrrolizidine alkaloids in botanicals. The EU is obviously working towards, when they discover that a contaminant, particularly when there is a known harm to humans, they will set maximum limits. And usually the discussion comes down to, well, what is an appropriate maximum limit to set in law? The UK implements those maximum limits. Now, the UK doesn't want to flood its market with food, contaminated food. So I think the points, once we sort of get down the line, will be a case of, do they look to the EFSA opinions on the contaminants? Do they look at the global JECFA, who work under Codex Alimentarius, for their opinions, and then will they then form their own decision on the maximum levels? Or will they stick to the, sort of, will they work to the EU maximum levels? That we don't know, and obviously that is what kind of trade deal position we end up with in the EU will obviously have an impact on that as well. Where there is some difference, on occasion, the UK would actually prefer not to set maximum limits, but prefer, on cases like the PAs, the pyrrolizidine alkaloids, working with industry, they have already found a drop in the occurrence of PAs in herbal teas, simply by industry, working with industry, and industry going back and looking at the good agricultural collection practices, and they have been able to make quite a dramatic reduction in PAs. So there are certain cases where the UK's sort of preferred position might be not to implement an actual limit, but to have guidance and liaison with industry to work to those limits. Now, that doesn't work as part of the EU28, but whether the UK will occasionally go down that route or whether they will actually stick with fixed maximum limits in order to facilitate trade, we don't know. With the food additives, there are a few issues currently ongoing. Dilutable food supplements, you know them as effervescents or powders. When the additives regulation became, back in the new additives regulation came out in 2008. In 2011, they published the annex to the regulation. And that was supposed to be a simple sort of transposition of the requirements of the food additives directives and the sweeteners directives and so on, just into the food additives regulation. Unfortunately, in that process, no exaggeration, hundreds of errors were made across not just food supplements, across all food sectors. And in the years since 2011, the industry has been fighting on a number of cases to have those errors corrected. Because rather than just saying, an error's been made, yes, we will correct that error, industry now has to justify why the error needs to be corrected. One of the errors is the level of sweeteners in dilutable food supplements. Under the old directives, the levels of sweeteners were based on the product as consumed. And certain levels of sweetener, therefore, on the product as consumed, if it was a tablet, or if it was a diluted food supplement in a drink, you would effectively be having the same control. Under the new regulation, we have been told by the Commission that it is not the case anymore, and food supplements don't benefit from the exemption on Article 11.3, which allows for levels as consumed, and so all levels are based on as marketed. The problem with that, if you actually produce a powder or a tablet for dilution in a drink, with the level of sweeteners on an as marketed basis, so effectively as that powder or tablet, when you put that into a drink and to make it, to try and drink it, it's disgusting. It's absolutely disgusting. Because you haven't got the level of sweetness, because when you're drinking it, it's on your tongue for quite a long, you're not just swallowing it and it's gone. You're getting quite a lot of the taste. And an awful lot of vitamins and minerals without, particularly the vitamins, without masking with the sweeteners, they are foul. So we've had an application go in after years of negotiation. Food Supplements Europe, which is our sort of colleagues in Brussels, have put in an application for 6 of the intense sweeteners with a view to saying, well, okay, can you do sort of effectively an extension so that you add in just for these dilutables, levels are based on an as-consumed basis, and apply the same levels as you would have for a liquid food supplement. So we will see where that goes. Chewable tablets, another one, same issue in terms of sweeteners, but this is the problem because they are crunchable. In the French, I believe, are the only country where they have a distinction between chewable and crunchable. And that's caused a problem. These chewable, crunchable tablets are actually currently excluded from all categories in the additives regulation, because we have categories 17.1, 17.2, and 17.3. 17.1 is for solid food supplements, which would encompass effervescent tablets and powders as well, and all other tablets. But in the descriptors, it specifically excludes crunchable tablets, chewable tablets. And then when you go, 17.2 is liquid, so irrelevant. 17.3 is syrup type and chewable forms. But it also specifically excludes chewable tablets. So we have an issue at the moment that chewable tablets, these crunchable tablets, don't actually exist according to the descriptors. And we also have the problem that the level of sweeteners in them needs to be higher. It needs to be the same amount as in other chewable forms. But currently, again, that's a discussion going on. And even though we have taken samples of these products, I actually took them to our contact in the UK Food Standards Agency, and she tried what it should be like, and she then tried one of these. And I felt very sorry for her because she didn't have any water there, and her face after trying it, because the B vitamins in particular, just disgusting. Syrup type food supplements, we have these bizarre categories, 17.1 solids, 17.2 liquids, makes sense. They then created, out of nowhere, this third category, 17.3 syrup types and chewables. Previously, syrup types were sort of effectively controlled by liquids, and chewables would have been solids. And it was just a few of the additives had the extra, so they were allowed in syrup type and chewables. So instead of sort of putting those as conditions under the liquid solid, they created an entire new category. The problem is syrup types are actually liquids, and they still need preservatives like liquids, because they are not syrups in the nature of being high sugar content. They're syrups by the nature of their presentation. They are gloopy. So a consumer will know if they're buying a syrup, it's going to come out, it's very viscous. No, non-viscous. Oh, it's gloopy. But if the liquid, they know what it's going to be like. But again, we've got the problem with, the Commission is now saying they want a definition of a syrup supplement. Well, when you have syrup supplements that are actually, you may get the occasional one which is high sugar, but most of them are actually with sweeteners, and then there's other additives in there creating this syrupy texture. To find a definition that will encompass all syrup supplements, not excluding any, is actually going to be incredibly difficult. So we have that issue ongoing. And then the last one is additives in supplements for infants and young children, where, again, they were a bit of a grey area. Some member states under the old directive didn't allow them at all. Other member states just allowed the additives that were in food supplements could be used in supplements for infants and young children. This isn't going to, the way the Commission's going at the moment, there's not going to be too much impact on Ireland, because the national policy is for vitamin D only, and currently the tocopherols are in the sort of the green list, so it might be allowed. Apart from, the Commission is looking at the list going from 4 months at the moment, and the Irish policy is from birth. So there are still a few issues. But in the UK, the national policy recommendation for babies 6 months up to children 5 years, is for vitamins A, C, and D. But the additives that are currently sort of on the green list won't allow a product to be formulated containing those vitamins. So we've now been given what's called an orange list, and they have finally, after a lot of discussion, put a preservative on there. But again, it's all got to go for EFSA for review, and the list, regardless of, if the green and orange list is allowed, the majority of products could remain on the market, but the majority of those products will have to be reformulated because they're currently also using additives that aren't on those lists. It's an interesting situation. The UK FSA are very supportive of the industry's views because the interpretations under the new regulation, the new interpretations, the UK FSA don't really agree with. They know how it went under the directives and what the interpretation of the directives were. So it's quite possible, we don't know, but maybe in the UK, post-March, we can continue using our chewable having our chewable, crunchable tablets with the necessary sweetener levels. We might have preservatives in our syrup-type supplements. We'll have our supplements for infants and young children, the right additives. And the levels for dilutable food supplements, I don't think there's any disagreement that, certainly in the UK, the levels for liquid food supplements is a logical step. We believe that has the agreement of the Commission at the moment, sort of verbally, but it has to go through the process. But who knows what's going to happen in Ireland and the rest of the EU in terms of the other food supplements, where that will go, we don't know. So I'm just realising I'm running out of time. Maximum levels is another area of food supplements that isn't harmonised. It's been under discussion since 1993 to the present day in the EU. So they cannot reach an agreement. One thing that has improved is back in the early days of discussion, a majority of member states wanted to work on a multiples of RDA basis. 1 times, 2 times, 3 times RDA. No logical basis behind it, it just gave them a nice figure. Thankfully, the majority of member states now are recognising that the RDA, multiples of RDA, is not a scientific way to proceed, and actually the maximum levels need to be based on safety. They need to be based on risk assessments and safety-based. And so that's a good move forward. But in the UK, we don't have maximum levels in the UK. We have label advisory statements. So there are 10 statements that were agreed with industry back in the early 2000s for the vitamins and minerals listed there. And they basically, as an example, zinc, they give above a certain amount of that nutrient, you have to put an advisory statement of what might occur. With some of them, they actually give then a higher level where they say if you're going above that level, encourage reformulation. The rest of the EU, well, not the rest of them, most of the rest of the EU is looking to maximum levels. And many, many, many member states have now got or are working towards national maximum levels because, as I say, the harmonisation just hasn't occurred. The problem with maximum levels is not all vitamins and minerals have the same level of risk. And you have some where there is no evidence of risk to human health, even sort of at levels far greater than you would consume from a food supplement on a daily basis. So Food Supplements Europe produced a risk management guide which actually looks at separating the vitamins and minerals into 3 groups. Those that have no risk to human health, those that have a fairly big division between the sort of the NRV, the nutrient reference intake, and the upper safe level, and then those that are very close to it. And they actually propose maximum levels for food supplements, taking into account the fact that foods are also being fortified with those supplement levels. And I understand a similar approach has actually been taken in Ireland as well, by a scientific body in Ireland. So, post-March, will you end up with harmonised maximum levels in the EU without the vocal UK? Because the UK have been very vocal anti-maximum levels up till now. So Will it mean that with the UK out that you can finally reach agreed harmonised maximum levels? We'll have to see. I've realised, I'm getting close on time. Going on to the final one, looking at health claims. Yes, I think health claims will be on, as Pat suggested, will be on the list of things to be amended, because the view is the health claims regulation is not working as it was intended to work. There are the wordings of the claims. When you can't say that vitamin C is an antioxidant, which is something that the consumers understand, and instead you have to say that vitamin C contributes to the protection of cells from oxidative stress, there is a big move that really the wording needs to be simplified. Probiotics also, another area which, with the UK coming out of the EU, they may start to allow the term probiotics. Other areas of the health claims, I'm not sure that the UK don't want to go down the route to where it was in the early 2000s, where it actually, well, I'm not going to say kick-started the health claims, because the health claims regulation was actually 26 years in the making, and it was rushed at the end, which is why it doesn't really work ideally. But the UK doesn't want to go back to those days, but the industry in the UK would like to see something that is more consumer-friendly. The botanical herbal conundrum, as I've called it here, which is I'm going to focus on in the last few minutes of my presentation. Botanicals and herbals are plants. They're plant powders, they're plant extracts. The difference is simply the terminology. For food supplements and functional foods, we tend to use the term botanicals to describe those powders and extracts. In medicines, we tend to use the term herbals, and that's generally the term for the powders and extracts used in the traditional herbal remedies, the traditional herbal medicines, which are registered under the Traditional Herbal Registration Scheme, so THR for short. So traditionally, herbals go into THRs and botanicals go into food. So that's a very simple issue. But that's where the simplification ends. Again, this is not harmonised across the EU as yet. We have the problem that the same plant can be considered to be a botanical in food in one member state, but it is considered to be a herbal medicine in another member state. So St. John's wort and echinacea, for example, are not allowed in food supplements in the UK, and I don't believe they're allowed in food supplements in Ireland either. I know Ireland and the UK are quite similar in how they view the botanical herbal issue. So it means that you then have a barrier to trade with that. We also, on very rare occasions, we've had our first case, I think, in the UK, the same plant might be considered both a botanical and a THR in the same country. We do have cases where you have a traditional herbal registration for a mixture that will encompass some plants which are also accepted botanicals. But in this case with milk thistle, we actually have a situation where we have milk thistle is a registered traditional herbal remedy, and we now have a milk thistle food supplement. Now, whether they are, where you get, it's particularly food supplements because by their form, they are already on the medicinal appearance. Every case of whether a product is a medicine or a food is assessed. It's assessed on a case-by-case basis by the UK Medicines Agency. In this particular case, the borderline team said, no, that particular product is a medicine. The company went to appeal on this, and the appeals board actually said, no, it can be sold as a food supplement. So we now have the totally bizarre situation where we have milk thistle food supplement, and we have the milk thistle THR, but the food supplement is actually providing a higher dose than the THR. Yet it's the THR that can make the claims. So it's a little bizarre. So we have the Nutrition and Health Claims Regulation, and that has applied since July 2007. There were 44,000 Article 13.1 claims were submitted from across the EU. Now, there were many duplicates in that submission, and the Commission narrowed it down to approximately 4,000 by taking out the duplicates, by merging some of them. I can't say we agreed fully with all of the mergers that occurred, but they got down to around 4,000 being assessed. Now, I was on the industry list. I was on the panel working on putting together the industry list. My remit was looking at the other substances. And I have to say, EFSA, thought they had a lot of problems, but they should have seen some of the stuff that we were submitted, and we just threw out. It didn't even make it to the industry list. Article 13.1 claims, I have to say, they were not dossiers. They were very, very simple applications. It was basically, there was a list of references, there was the proposed claim, the proposed conditions of use. There was none of the description of saying how, pulling out the science from the references and saying how this applied and where they came from. It was simply one line in a spreadsheet. So when you sort of got, I assume it happened here as it did in the UK, the media saying, all these dossiers rejected. They weren't dossiers, they were simply one-liners. 2010, there was a lot of problem because a number of botanicals had already been assessed and received negative opinions from EFSA. And there was a recognition by industry that the very high gold standard that EFSA are looking at, basically wanting randomized controlled trials and so on, which you don't get for many food ingredients, there was absolutely no way on earth that botanicals would get through that kind of assessment. Whereas you could have, like I said previously, you have a THR making claims which actually has a lower content than the food supplement that can't make the claims. And it's based on the traditional the claims that have traditionally been used for that herbal remedy. So in 2010, just over 2,000 botanical claims were put on hold. There were a few other claims put on hold as well, but I won't go into those. And, sorry, I'm going backwards. And that's currently 7 years on, we're still in the situation with those claims on hold. So, situation of botanicals at the moment, they're not harmonised. Many member states are now producing their own lists of what, so that they can actually, they will say this is permitted or this isn't permitted in food supplements. Belgium, France and Italy worked together and produced, they collaborated on an extensive list known as the Belfrit list, which the three countries, Italy has now definitely implemented. I think Belgium has partially or is going to be coming in, and I think France is working towards implementing it as well now. But even there, they produced this list that they all agreed on, but each country actually still has a few, at least one or two botanicals where the other two countries didn't agree, but they've retained it in their own national list so that their own national members can continue using them. The problem that is stopping the creation of a harmonised list, or the problems that are stopping, we have this medicine-food divide, where some countries will consider certain plants to be on the medicinal side, and others consider them to be on the food side. So that's quite a difficult division to get across. Concerns have been raised about the quality and the safety of botanicals and food supplements, and there's also the problem with the evidence base. A lot of the botanical claims are made on traditional history of use. Now, a lot of that traditional history of use is also on the medicine side. So there are a lot of problems there are a lot of issues creating problems with the creation of a botanical list. The whole issue of the botanicals under the health claims has been part of the refit assessment under the Nutritional Health Claims Regulation, but that assessment is also looking at quality and safety as well. So the consultation is still to be finalised. There's been a consultation which went out to member states, industry and consumers. Initial findings are saying that there are polarised positions, which is unsurprising. A similar consultation undertaken by one of the European trade associations back in 2002, I think it was, 2003, had polarised positions back then. And to be honest, it hasn't changed. You still have a difference between food and pharma. You still have the problems, difference of opinions between industry and consumers. And you still have a division between member states. But yet harmonisation at EU level is still considered the best way to go forward, because just to try and ease the trade situation, it could give more legal certainty, it could help resolve issues with the product classification. The safety, and this is something that industry has been trying hard to get across, the safety is actually already covered under existing legislation. there is actually regulation 1925-2006. There's Article 8 of that regulation actually allows for the assessment of other substances where there is a concern raised about the safety and at the level of consumption in member states. And they have already looked at a couple of plants under that. So the safety is actually already covered. Apparently suggestions for a way forward are to be included in the consultant's final report, but that's unlikely to be resolved by March 2019. In fact, I think one of the states I've heard is going to be end of 2019 for this. So post-March, will you eventually have work in the EU to commence a new framework on the harmonisation of botanicals? Will the UK, well, I can tell you the UK is most likely going to follow that work in terms of watching that work. Will they implement it? We don't know. Will the UK retain the current assessment of, these? We don't have a list of what they consider medicinal, because as I say, it's on a case-by-case basis, but there's a general understanding of what is and isn't accepted, certainly within consultants and trade, and we advise industry. So will the UK retain that status quo? Botanical claims, will the UK allow the best claims for botanicals based on the evidence provided by the company? We currently have the Advertising Standards Authority who look at, they're a self-regulatory body, they look at claims, and on the claims that are on hold, the UK allows the claims on hold to be used, provided the company follows a number of conditions, one of them being that it does not appear on the non-authorised, on the EU Register of Claims. And where the ASA have assessed the claims, they look at the register. Okay, it hasn't been non-authorised. They look at the EFSA opinion. It was received a negative opinion if it's already been assessed. And so they say to the company, well, what else have you got? And the company will then provide what they've got if they have anything subsequent to the EFSA opinion, and the ASA will then review that. So if the ASA then consider that the company has provided enough information beyond that, then they would allow the claim. But I don't believe there's been a complaint yet that's not upheld. I think they've rejected the data. So who knows? So conclusion, and I'm sorry I've overrun my time a bit. We're unlikely to see many, if any, changes in the UK affecting food supplements for the period immediately after the EU exit. You've all heard the various implications of what kind of deal we have, what kind of exit, but I think certainly on the food supplement side, it will be going on the status quo for the time being. Longer term, though, a divergence could be seen. And that raises a lot of questions in terms of, particularly on sort of the labelling and the composition side, an awful lot of trade, a lot of food supplements in Ireland come from the UK. So how that's going to affect what comes into Ireland? Will it just mean that they can't, at the moment they don't have to even change the label because of course the language is the same. So if we end up diverging too far, companies are going to have to not only do different formulations for other EU member states, sort of on the mainland, but they could potentially end up having to do a different formulation and different label for Ireland, which is incredibly expensive. And equally, we have supplements coming into the UK from other parts of the EU. Who knows what's going to happen with that? So at the moment, we can only make educated guesses. I have to say, I was one of the 48%. I hate seeing what the country's doing. And at the moment, I have to admit, I feel quite embarrassed being British when I see what's going on. But that's, unfortunately, we just have to try and work with the situation that we're in now. So thank you very much for listening.